Okay, thank you, Tony, very much. Like you said, my name is David Sykes, and I'm a member of the OERB board. And my job in real life is that I'm a certified mineral manager, which means that I manage minerals for both myself and other people. I work for a small non-operating oil company here in Chickasha, Oklahoma. And the difference between an operating oil company and a non-operating oil company is essentially we own minerals and we have working interest, which is a whole other breed of cat, which would be a whole other separate course on working interest. But what we're going to talk about today is the leasing process, and you can't really get into that without having your finger in a whole bunch of different areas. So I'm also a landman, so I have a background in land and working for an oil and gas company. You kind of hit the highlights, the high points of engineering and geology, and just a little bit of all of those things. Certainly do lots of land work and things like that. But before we get started, and we're going to try to move through this pretty quickly, I could probably spend 2 or 3 hours on just this subject alone, but we're going to try to go through this quickly and at least help you, if you don't know anything about leasing, at least help you identify some areas where and some resources where you go to get help. And the problem with this is that there are multiple perspectives on leasing. So, but before we do that, I just want to let you know that I'm not an oil and gas attorney or CPA, and there is absolutely no substitution for the counsel of professionals in each of these areas. Remember, not all attorneys are oil and gas attorneys. They all have usually a fairly basic knowledge of contracts and law, but that doesn't necessarily mean that they're well versed in the very specialized world of oil and gas law. So CPAs, of course, can give you advice on your financial planning and things of that nature. Please feel free to consult all those professional oil and gas people if you have specific questions about things. So nothing I should say should be construed as being legal or financial advice. I kind of have to say that. As I said before, I'm a certified mineral manager, which is a program through the National Association of Royalty Owners. I also do lots of education for them. I'm currently president of the National Association of Royalty Owners, as well as the foundation, which is their educational wing. NARO is a great resource if you're a royalty owner and you're trying to learn more about how to manage these resources that that we own. The minerals in the ground are owned by the royalty owners or by the mineral owners, which there's a difference between a mineral owner and a royalty owner, which we'll get to in a little bit later. But it's important to understand that the United States is the only place in the world that allows private ownership of minerals. As far as there are parts of Canada, but as a country as a whole, the United States is it. We're the only place in the world that allows the private individuals to own the minerals that are in the ground. And when we talk about minerals, for the purpose of today's discussion, we're talking about oil and gas minerals, not hard rock minerals like sulfur, gold, galena, which is lead, aluminum, steel, all those ores and those hard rock minerals that require surface to be changed are not part of our discussions as far as leasing goes today. The only one that might come into play sometimes with an oil and gas lease might be coal, which is considered to be a hard rock mineral. There are parts of coal that are related to oil and gas production in what they call coal bed methane, which is methane that's contained in between the seams of the coal. And a lot of oil and gas leases in old days didn't include coal bed methane because it wasn't interstitial in the rock. Most oil and gas leases today say that, hey, if you hit a coal bed methane well, we want to be paid on that. So the oil and gas lease, we're going to go over basically an overview. We're going to do clauses, the execution of that, and then some of the implied covenants if we get to that and have that much time. The oil and gas lease is the basic instrument in oil and gas development. When a company decides where they want to drill, they'll do a whole lot of work. before they decide where they want to drill. But before they can enter a piece of land and start drilling a hole in the ground, they have to make a contract with the people that own those minerals in the ground. Now, it varies from state to state. And if we've got folks on here that are oil and gas professionals or landmen, I'm sure they're well aware of the fact that the laws vary from state to state as far as whether or not you own the minerals in place or if it's a rule of capture state. Those things really don't have a lot to do. Those are kind of fine points of the law. They don't really have a lot to do with a mineral owner that is wanting to negotiate an oil and gas lease. And this must be a symbiotic relationship, at least from my perspective. I think it's important that we remember that the oil and gas company that is wanting to explore for oil and gas and the mineral owner that actually owns those minerals in the ground, it has to be a symbiotic relationship between the two of them, because we can't get at the minerals as mineral owners without the help of the oil and gas company. So they don't have the right to explore for those without our permission, for the most part. I mean, in a perfect world, that would be, the way that would happen. These are legal instruments that are executed by a mineral owner that's granting some of the rights to that property to the oil and gas company to be able to explore for land. And this is both a contract as well as a conveyance. In fact, it may be more of a conveyance than it is just a contract, because it actually, when you sign that oil and gas lease as a mineral owner, you're giving up a great deal of the rights you have to the property. So the courts in most states treat the oil and gas lease as a conveyance of some mineral rights from the lessor, that's a mineral owner, to the lessee, which is usually the oil company. It could be a speculator like a landman that's just buying up leases and then later will assign those leases to the company, which is a perfectly legitimate exercise that happens every day. I talk to a lot of mineral owners that get a little bit freaked out. They've been approached by someone and they find out that that individual is not an oil company, that they have no intention of actually drilling the well themselves. And they're afraid that if they lease to that individual, an oil well won't be drilled. And that couldn't be further from the truth, because just because you take a lease, that doesn't mean that you're in the driver's seat as far as controlling how that production is going to be go forward. So as we get ready to do this process, we need to understand some of the differences between real property and an actual lease. The lease has the right not only use the land, but take substances from it. The lease has the right, is limited in a term of years, but there are usually two terms in an oil and gas lease, which we're going to talk about a little bit later. So it also spells out the lessee's rights to use the land and are not exclusive and must be shared with the surface owner. So an oil and gas lease is more like a deed in some instances than it is just a contract, because you're actually giving up the right to use some of that property. So we oftentimes run into situations where the surface owner and the mineral owner may or may not be the same person. So back when the land was originally given, when the government either sold the land or doled the land out, it was in a what we call fee simple estate, which means that the minerals and the land were held together by the same individual. And in most instances, when the land patents were done, that's the way that the land was granted. And along the way, some people, especially like during the Great Depression, a lot of people that had farms and ranches sold part of the minerals to generate money so that they could keep the surface operating, so they wouldn't have to sell off part of the surface where they were actually making their money, because perhaps they had never made any money from the minerals, and so they sold part of the minerals. At this point, they've severed those two estates, the surface estate from the mineral estate. And we find that very common now, especially in Oklahoma and Texas. Oftentimes the mineral estate and the surface estate are owned by two different people. And then we get into a situation where an oil and gas company would like to come and develop those minerals, and they say, hey, we want to lease these minerals, and it's the mineral owner that makes the determination as to what those terms of the lease are going to be, not the surface owner. I've had calls from surface owners that own none of the minerals below their property, and they say, how can I stop this well from being drilled? Well, the courts say that the minerals are the dominant estate. We can't get at the minerals without encroaching upon the surface. So once the oil and company has satisfied the state requirements to prepare to drill that well, they have the right to enter that property and drill the well. Now, that would be a government taking if they did not negotiate with that surface owner. Absolutely, the surface owner has the right to negotiate for damages to their property. But as far as preventing them from doing that, no, they cannot do that. So with horizontal drilling now, if you get to a landowner that has a legitimate reason why they don't want to allow them onto their property, usually that can be handled by simply setting the well location off the property and drilling underneath. And because as most development now is horizontal, as far as deeper formations, we don't see too much of a problem with that, or certainly not as much as we did before. So essential provisions in a lease. So you basically have to have a few things to make this a legally binding contract. So you find most of this in three clauses: the granting clause, the Habendum Clause, and the delayed rental clause. So these change constantly, and one of the things you have to remember is that virtually everything in an oil and gas lease is negotiable. There are only about 5 or 6 things that are not negotiable, and those things are laid out mostly in the granting clause. So we're going to talk more about these in depth. The dates. A date is one of the things that all contracts must have to make it legally enforceable. The date, you're going to have 3 dates, or maybe as many as 3 dates on an oil and gas lease. It's going to have the date that it's entered into. That's going to be the effective date of the lease. That's going to determine how long that lease, because most leases have a primary term and a secondary term, and that lease is going to determine when that primary term is going to expire. So that date is important. It's also going to have a date when it was actually signed, and it should have a date that it was attested to, where it was notarized. And remember that notarizing something doesn't necessarily make everything in that document factual. It just makes it recordable. They're just saying that they saw and witnessed the people sign that. It doesn't, the people that having something notarized doesn't mean that it's a statement of factual being. So it doesn't necessarily mean that it is actually factual. So you have to kind of remember that, because there are oftentimes mistakes made in an oil and gas lease, and that unfortunately is an all too common occurrence that we have to deal with later on. So the last date you're going to see is a recording date, which will be placed on the document when the oil and gas lease is recorded in the county courthouse in the county where the land that's being leased is located. So the signature date is not usually an effective date unless that is the date that there is no date at the top of the lease. If there's not a date in the granting clause, then the signature date becomes the effective date as well. If there is no date where the signature is done, then it would be the date that it was notarized. In Oklahoma, it's going to have a date on it when it's notarized. If for some reason in another state there wasn't a date on it, then it would become the effective date would be the date that it's actually recorded. It must be recorded to be legitimate. So when you get ready to transfer ownership and someone wants a copy of the oil and gas lease, they're going to want to see a recorded copy. Okay. So it's really important that if you're a royalty owner, or even if you're an oil and gas company or a landman, that you keep meticulous records and that you know where you can put your hand on source documents. And one of those source documents is going to be the oil and gas lease, because it is the document that determines how future payments are going to be made by the company to the mineral owner, which at that point becomes a royalty owner. So the parties are the individuals. You're going to have the royalty owner, who's going to be listed at the top of the document in that granting clause, and who they're granting the rights to. So you're going to have two parties. Again, it's going to be required to have, for this to be enforceable, to be a legal document, you're going to have both parties listed. So if the land is held by private individuals, it needs to state that so-and-so, a married man dealing with his sole and separate property. If it's not owned in common with his spouse or partner, then it needs to be listed that way. If it's owned by a corporation or a trust, it needs to be listed that way. So it's important that that be listed accurately. On all the oil and gas leases I prepare, I like to put their address on that document so that you can see where they lived at the time that oil and gas lease was executed. So the same thing with the company, so that you have some sort of contact information. Most of the time, an oil and gas lease is going to be prepared by the lessee, not the lessor. The lessor is the mineral owner. The lessee is either the landman that's taking the lease that works for a land company, or it's going to be the oil company. They're the one that are having the rights granted to them. But as the mineral owner, you certainly have a right to review that, and it is your responsibility to be sure that they've not made an error, as you should understand how those minerals are held. Having said that, if you're dealing with a landman or a land company, or even an oil company, a landman that works for an oil company, they're land professionals, and you should rely heavily on them to be sure that they have done their due diligence and checked how this property is legally held, what name it is in. So both parties need to be listed and listed correctly on that lease. In addition to the granting clause is going to say for what purpose you're leasing. Now, this is where you can get into a little bit of a negotiation situation with the person, the lessee, because oftentimes they'll put in there, it can be as simple as this: you're leasing the rights to enter the property and explore for oil and gas. Does that include seismic? Does that include, building roads? Obviously, all of those things are going to be required to be done in order to bring a well to completion. But sometimes they really get a little bit carried away with the rights that they want the lessor to give up, in my opinion. As I'm kind of a royalty owner, mineral owner guy, I kind of look at the fact that, I don't think that we really need to give them the right to build pipelines or to build compressor stations or other things in that oil and gas lease. That needs to be handled with a separate document. So that's something that you need to be careful of. But that granting clause is going to spell out what they're getting and why. And again, something else that's required on any contract: who's doing it, when is it being done, what's being traded, what's being given. The consideration. On most oil and gas instruments, you'll see $10 or other valuable consideration. On older ones, you might see $1 and other valuable consideration. A lot of times, mineral owners are confused and they think, wait a minute, you said I was going to get $100 per acre. But it says on the document I'm only getting $1 total and other valuable consideration. because this is filed in the county courthouse and is public record and anyone can look at this, they do not list the actual amount of money. I personally, as a mineral owner, don't want anyone to know how much money I got for my lease. And the oil company probably doesn't want that either, because it sometimes hinders them in their future negotiations. Just like any other business, you want to buy it cheap and sell it high. So they're going to try to negotiate the lowest price they possibly can. And if everybody in the world knows they paid an outlandish amount for a piece of property, it's going to be hard to back that off. So don't be concerned if you see on the oil and gas lease it says that the consideration is $10 or other valuable consideration. That isn't the money necessarily that you're going to be paid. But in order to make a contract legally binding, money has to have exchanged hands. And that's the reason why that's on there, is that a consideration is listed. They're going to pay an oil and gas lease, a lease bonus, at the time that at the time a lease is executed and the parties have agreed to it. Sometimes the oil and gas lease bonus is paid at that time. Sometimes the company may have negotiated a period of time after you've signed the lease and they know that you're serious about moving forward. They will request 30 to 45 days to verify the title. I will give them a copy of a signed oil and gas lease that has been notarized, but I will not give them the original, and I'll stamp copy on the one that I give them so that they can't record it until they pay me the bonus. My policy is that I trade them an original executed oil and gas lease for a bonus check. So after I give them the copy, they usually have 30 to 45 days for their landmen to go out and make sure the title is proper. If not, they'll come back to you and say, you don't own as much as what we thought, or you own more. That's another reason why you should know what you own, is so that you don't get caught in that little problem right there. So ultimately, the royalty owner is going to be the person that's responsible for managing their property, because this is an adult thing. So at any rate, remember that that's kind of how that works out. Delayed rental payments are usually deferred payments that for the additional years of the primary term, and it's usually $1 per acre for the second and third years of the primary term. The primary term is a negotiable term on that lease. Most oil and gas leases that you see have a 3-year primary term. So if you leased it for a $100 per acre and you had 5 acres, so you'd get a $500 bonus for signing that today. And then at the 1-year anniversary, you'll get a $5 check. And at the second anniversary of signing that, you will get another $5 check. And those are called delayed rentals. Most oil and gas companies no longer practice delayed rentals. That's kind of something from older era. But what they do now is it'll say at the title of the document, it'll say oil and gas lease paid up. And what that means is they're paying you all the money up front for the primary term. So if you lease them for $100 an acre, you'll get that $500 up front, and you're not going to get any, if it says paid up on it, you're not going to get those delayed rentals. If in some instances, some older companies, when you get your oil and gas lease payment, it may be for $510 in this particular instance, where you leased for $100 an acre, and they'll go ahead and add those $2 for those additional 2 years. They'll go ahead and add that into the price. So instead of getting a flat 500, you'll get 510. That kind of throws you a curveball sometimes, but some older companies, that's just the way they like to do business. They pay you that $1 delayed rental up front in a paid up lease. So royalties are when a producing well begins. And so when you have minerals and you begin to collect money for it, you are now both a mineral and a royalty owner. So that's kind of the difference between those two terms. Is royalty refers to money, and it is possible to sell your royalty to someone else and still maintain ownership of the minerals. You can give half of the royalty to your church or half the royalty to your children, and you would still get paid half of the royalty, but you still own all of the minerals. Royalty and working interest are tied to that lease document. As long as that lease is in effect, then that's what defines how the royalty is going to be paid. There are documents that you can use to alter how that royalty is paid, but you can't alter the terms of the original lease as far as how the lessee is going to operate that lease. So that would be, well, I suppose you could do that, but it would require both parties to agree on a renegotiation of the lease, which has been my experience, except in very, very rare circumstances, is not going to happen. I talked to a lot of royalty owners that have properties that they have inherited that are held by a 1/8 lease, and they would love to renegotiate that to a quarter royalty. But if you can get the oil and gas company that owns those leases to agree to that, let me know how you did that, because that, you're talking about doubling your royalty, and they're going to have to pay that out of their working interest portion. So that's probably not going to happen. So the actual amount of the consideration is not recorded on the oil and gas lease. You'll get a check that will usually spell all that out on the check skirt. And again, that's because, you know, you don't want your neighbors going there to find out how much you lease those your minerals for. You know, they saw you driving a new pickup, and they thought maybe you got an oil and gas lease, and so they don't put that on there. However, it used to be common practice many years ago that you would put your social security number or your tax ID number on an oil and gas lease. Do not do that. If there's a place for that on the oil and gas lease, do not put that on there. Almost all oil companies are going to require that you give them your social security number or tax identification number, but they will not require that you put that on the oil and gas lease. They'll require that you give them a form that has that on there available from the IRS, and because you don't want that being recorded of public record. You'll see that in older oil and gas leases. Lots of folks' social security numbers are just out there for everybody to see, filed, you know, in the county courthouse. And with all that online now, a lot of that, some county courthouses are redacting that information, but on the older documents that were scanned many years ago, is usually not the case. So oftentimes an oil company will say, well, you take this site draft, which you have 30 days to process, and you take that to your bank and turn that to your banker with the oil and gas lease, and then we will pay from that draft after we've verified the information on the oil and gas lease. I don't like, and in fact, we had an oil and gas company several years ago, you know, just insist that we use a draft, took it to our banker, and no one in the bank knew what to do with a site draft. So we had to explain it to them, and I called the company and said, just send us a check and we'll give you the lease when we receive the check. So so that's kind of how that works. I mean, again, all of these things are negotiable, and most people now don't use drafts like they used to. So remember the legal description that we talked about. This is describe the actual location of the property and the minerals where you own that property. It's described as a surface location, but does not necessarily describe that you own the same description on that surface. So there are several different ways to write these, and we run into that with different states. The original 13 colonies and areas that were settled early on, you know, before our country became the United States, use a meets and bounds system to describe that property, which is where you use landmarks, rivers, trees, rocks. Sometimes an actual benchmark where a stone or something had been placed there. I know we've run into states where they use like rock cairns, which are a big stack of rocks. And in Texas, a lot of their descriptions are meets and bounds descriptions, which are extremely, can be extremely complicated. When the Spanish government began to give land to settlers in what is now Texas, they oftentimes would describe that land beginning at a point of beginning at a mesquite tree 6 inches in diameter. And this may have been in the 1600s or 1700s. That mesquite tree is probably not there anymore. So a lot of those descriptions can be archaic, to say the least. In Oklahoma, we're very fortunate, and most of the western states use the U.S. Rectangular Survey, which they began using that shortly after the Revolutionary War in Ohio, where half the state had been will use meets and bounds, but then when they needed to give land to Revolutionary War soldiers for payment of their service, they began to use the meets and bounds system, because remember, our founding father and first president George Washington was a surveyor by trade. So they kind of worked all that out. These are not difficult to figure out, but there is kind of a system to that. There's lots of information on the internet that can help you understand these land descriptions. But the important takeaway here is that the land description needs to be adequately described on the document, so everybody understands what land is being leased and what rights to what land you're willing to surrender to the oil and gas company. Remember sometimes that you may own a 1/5 interest in the southwest quarter of a particular section, township, and range. So that's a 160-acre tract. But if you only own a fifth of that, then you're going to have to divide that 160 acres by 5. So on the oil and gas lease, it's just going to be that you're leasing your minerals in the southwest quarter, containing 160 acres more or less, is the way that's going to be written. That's not saying, we have people come to us all the time and say, no, it says I own 160 acres. No, you have to go back to the original source documents, which most people today that own minerals inherited them. Few people have purchased them, but at some point you're going to have to research that title and find out exactly where they came from. Just because it says on an oil and gas lease that you leased a tract of land that had 160 acres in it, those are the gross acres, not necessarily the net acres. So you don't necessarily own that 160 acre tract or the number of acres described by the tract of land that's being described on the oil and gas lease. Important to remember that. Know what you own, know where you own it. The Habendum Clause, very confusing. It's the only clause that the title of it doesn't really tell you as English-speaking people what it does. A Habendum Clause refers to time. That has to do with the term, how long, when it starts, and how long the rights continue. So the primary term is a maximum period that the lessee can maintain these rights on the oil and gas lease without drilling a producing well. The primary term can be surrendered. It can be affected if there are delayed rentals being paid or not being paid. The secondary term begins as soon as production is established. And in most leases, you'll see it written as that the primary term is listed first, that these rights shall continue for a term of 3 years. Again, that's all negotiable. Or as long thereafter as hydrocarbons are being produced in paying quantities. The devil is in the details on everything in an oil and gas lease. Remember that. It's how it's written. As long as a producing well exists is not the same thing as a well producing in paying quantities. As the lessor, you want to limit the amount of time that the oil and gas company has to hold on to your rights. This gives you the opportunity to renegotiate your terms. So if an oil and gas well is barely producing and it's costing them more to remove the oil and gas from the leased property than what they're making on selling it, and as you can see with the inimical climate that we're in now, that can happen very easily. I mean, you go from $70 a barrel oil to minus $32 a barrel oil. That changes the scope as to whether or not those wells are producing in paying quantities. Now, we're not going to see negative prices on oil again, knock on wood, but it does make a difference when we drop from $40 to $20 a barrel, especially on marginally producing wells. And remember, taxes and royalties have to be paid out of that. So if they're not economical to produce anymore, that language in your lease allows you the ability to perhaps cancel that lease and renegotiate a new lease for future development. So it's really important that you remember what those terms are and when they start. The royalty clause. This is, again, is talking about money. So the royalty is the share of the production paid to the lessor. So it's kind of an unusual name for our lives over here in the Americas. But if you think back to where most of our law came from, common English law, and back in Angleterre there, the royalty share was based upon the landlord that owned or managed the land, and he allowed peasants, serfs to use the land, to till the land, and they would pay him a royalty of all the crops that they produced, or the animals that they harvested from that land. Or if they sold the crops, then they paid him a royalty share, a percentage of what they made. And as you can imagine, that was the only way he had to make his living. And he was, so by definition, my point is royalty is cost-free. That was the original definition of royalty. So
hey,
you're going to be paid. Yes.
We do have a question real quick.
Sure.
It says, I understood the 1/8 to 1/4 doubles royalty payment, but why is it based on eighths?
Because 1/8 is the minimum royalty by law that can be offered. This goes way back in the days when people were uneducated about how this all happened, and some of them were being taken advantage of and signing oil and gas documents that they regretted later. And so the courts decided that 1/8 was going to be the minimum royalty that could be paid to mineral owners. So it starts at an eighth. With Native Americans, the minimum royalty is 1/6, at least in Oklahoma. So I kind of shy away from that because dealing with the Bureau of Land Management and the Bureau of Indian Affairs, they have many, many, many more regulations than what the standard Oklahoma state statutes. And I don't have a lot of knowledge. That's one of the areas where we're going to get into where I'm going to say I'm not an expert there. So, but standard oil and gas bottom basement lease is going to be a 1/8. And
Awesome.
You can decide whatever you want. Anything you can negotiate with the oil and gas company and get on paper, certified and filed at the courthouse. Good for you, that is. So, you got another one?
Yes, we have one more. Can you explain Blanchard rules in Oklahoma?
That Blanchard is that minimum 1/8. And the Blanchard has for the most part been set aside, and they don't follow that other than the minimum 1/8. But when you see it's now common practice that if if you negotiate a lease for a quarter, oftentimes you'll see them break that out on the on your check runs, and you might see something listed as a BL, which could be, depending on the abbreviation, it may say in the legend on the oil and gas, because every different company uses a different software, and so you've got to kind of find out what all those abbreviations they put on your check runs are. But that BL usually stands for Blanchard, and what they're doing is they're splitting that out a 1/8, and oftentimes some companies won't charge you any post-production costs on that 1/8, and then they'll charge you on what they refer to as excess royalty, which would be anything above that standard 1/8 Blanchard. So, and on older documents, you'll oftentimes see them listed as, and you see this in poolings all the time, that you'll get a 1/8 royalty plus an excess royalty of 1/16, which is a total of 3/16. And oftentimes it's just the way that a lot of that is, it's just always been done that way. And I can't speak, not being a legal scholar, I can't speak to exactly why they write them that way. It is a little bit confusing. And I think for the new initiate to oil and gas, some of these things are, it almost seems like, you know, they're confusing by design. So knowledge is power, and that's why all of you are here today, is to try to learn a little bit more as to how to manage and negotiate a good oil and gas lease for you and your family. Because remember, all over the country, I've seen oil and gas wells in California that have been producing for over 100 years, and they're held by the lease that was signed, you know, in the 19 teens. And so you could be dealing with this oil and gas, these oil and gas leases that you're signing today. Your posterity could be dealing with those, and it could be affecting how they get paid going on in the future. So especially with the natural gas resources that the mid-continent region of the United States has, and with, you know, our country's desire to no longer be dependent upon foreign sources of energy, it could be a long time that we get paid. And so the oil and gas lease is an extraordinarily important document, because it lays out exactly how you're going to get paid as long as that lease is in force. And with the secondary term kicking in, as long as production is maintained, they're going to maintain that lease. And when one well begins to wane, they simply go in and drill another well to maintain that lease and keep production established. Because remember, these leases are for the whole property. They're not limited to a single well bore unless it specifically states that. So, and a well bore lease would be, again, most companies are not going to agree to that. Remember, it costs, on a vertical well, not a horizontal well, it costs $3 million to drill a vertical well, as much as $11 or $12 million to drill a horizontal well. And none of us can afford to pay for that as mineral owners. The oil and gas company, they're taking all the risk. And on a vertical well, those risks used to be about 50%. So they had a 50 to 60% completion ratio, depending on how good their geologists and their maps and their engineers were. 50%, 40 to 50% of the wells that they drilled were non-producing, and they were out that $3 million. If you participated with them, you'd be out your proportionate share, and the only thing you get is a nice tax deduction. So, and that's sometimes not very helpful. So they're taking all the risk up front, which is why they're getting the lion's share of the production. And I sometimes have to remind landmen that, hey, you know what? You want me to sign a 3/16 lease? Remember, who owns that oil and gas in the ground? I do. And if I'm only getting 3/16, you're getting 13/16. But the argument on their side is that they're taking all the risk. And then this also leads into the argument of, what about post-production expenses? Compression, dehydration, building pipelines. Who's that expense on? They have a fiduciary requirement in my understanding, in my belief, to market that oil and gas for you. So that should be on them, in my opinion. Remember, royalty, cost free. But I have a lot of leases where I'm paying 40% post-production expenses on. Not happy about that. So remember, that's your product in the ground. We just can't extract it. We don't have the money to be able to drill a well to extract it and go through all the legal processes. You know, some of these petitions they file with the Corporation Commission in lawyer fees and fees with the Corporation Commission, they may be paying $50,000 or $100,000 just to file, you know, a pooling. So it is extremely expensive, and the oil companies have the expertise, and that's where this symbiosis has got to. That's got to be the nexus of that. Is we've got to, you know, work these out. Dry hole clauses, cessation, continuous drilling. These basically state what happens in the instance of a dry hole. If they drill a dry hole right at the end of the primary term, and they get ready to drill another well, it usually will state in there that if they have a dry hole, they have 30 to 60 days to begin operations before that lease expires to try to get another well going. So they can extend the lease forever that way, but it does give them an opportunity to maybe move over to a different part of that section and try to drill another well that would be a producing well. I mean, we want them to drill a producing well, especially if we've done a good job negotiating our oil and gas lease. So again, you kind of have to pay close attention to that. Cessation of drilling that basically says what happens in the event that production stops for some reason. The well paraffins up, they have to get a workover rig in there. If they may not be able to do that the day after the well stops producing. It may take them 30 to 90 days to get a workover rig in there and reestablish that production. They could have multiple problems, and especially in the days of horizontal production now, I'm hearing horror stories from vertical well owners that have had their well bores crushed by hydraulic fracking actions. So, you know, there's that little battle going on between big producers and small producers. Again, we just kind of get caught up in that, and we need to understand that they want to produce that well too. There are a lot of wells that are shut in right now because of low prices. So shutting in a well, we're relying on the oil company's expertise when they shut that well in, that formation is not going to collapse. And when they open that spigot again, that nothing comes out. We're relying on them to handle that appropriately. And hopefully, you know, we'll see production come back. And honestly, I'd much rather be paid at $40 a barrel on my oil or $3 an MCF than I would be paid at $10 a barrel and, you know, 99 cents an MCF. So, because as a royalty owner, when that oil and gas, when those minerals are produced and that formation is played out and ceases to produce, we're done. Unless we have royalties somewhere else, you know, that's it. Our piggy bank is empty and we don't get paid anymore. Oil and gas companies are in the business. Part of their business plan is they continuously go out and lease and buy more minerals. So they have a continuous stream to be able to go and drill and produce more energy and more money. But for the royalty owners, I just soon get paid at higher levels than I would at lower levels, because once everything in my garden is gone, I don't have anything else to sell. So these are non-renewing. There may be other formations that are producing out there, and there may be new technologies that allow us to re-enter some of those old formations that we thought were no longer productive, in the instance of like horizontal drilling and steam injection and CO2 injection, a lot of other things that that newer technology is allowing us to get more of that energy that's trapped down there out. That's all good things as royalty owners, and it all depends on how you want to manage it and when you want to get paid and how you want to get paid. So continuous developing, drilling and development. In some states, a lease will expire if they don't drill a new well every year. So until they've maxed out the number of wells that the Railroad Commission or the Corporation Commission will allow them to drill in a particular area. So this clause decides how that gets handled. Pooling and unitization, that is not to be confused with a pooling clause is not to be confused with forced pooling in Oklahoma. Some states don't have forced pooling. I personally think it's a good thing. It allows the oil companies to move forward when they have royalty owners that just don't want to sign a lease or won't enter into a negotiation, or they have a green streak and just don't think that the oil and gas ought to be produced at all. This allows them to go ahead and doesn't hold the rest of us hostage because you've got a royalty owner with, or a mineral owner rather, with 10 acres of mineral that refuses to sign an oil and gas lease. This allows them to move forward, and if they pay attention to that process, they get fairly. Some people don't like it, but it is, it's something that we have in Oklahoma, a tool that we have in Oklahoma that we can work with. Other states don't have that, and quite frankly, I think they're archaic and more complicated than the ones that we have. So Mother Hubbard Clause, both a good and a bad thing, depending on your position. This one basically says that they're leasing everything that you have to lease, whether properly described or otherwise. So most people want to strike that. It depends on how it's written. If they're leasing in a 160 acre spacing, like in the northeast quarter, and you own minerals in the southeast quarter, and they put a Mother Hubbard Clause that says everything in the section, you just leased everything in the section. At least they're going to argue that, even though it wasn't described in the northeast quarter. The southeast quarter where you own wasn't described additionally. You don't see too big a problem with this anymore. It also can kind of can be a solution for you if you put in the description that is your intent to lease all the oil and gas minerals that you own in that particular section, whether properly described or not. That should eliminate the need, if there's a scrivener's error in the description, of you're getting forced pooled on acreage that wasn't included in that description. So 6 of one, half dozen of the other. Again, know what you own, know where you own it, and negotiate from a position of what's going to be best for you. Damage clause, that basically just says that they're going to pay for damages that they cause to the surface. It helps eliminate the royalty and mineral owner from being held accountable for damages that are done to the surface owner's property. Should be negotiated completely separately. I always put that in my oil and gas leases, that just as a favor to the surface owner, that they're going to negotiate for surface damages separately from the oil and gas lease. So compliance clause just says they have to comply with all state and federal regulations and the EPA and all the legitimate entities that have a legal right to oversee the production of oil and gas. Surrender clause talks about how, if they want to surrender that oil and gas lease to someone else, they want to sign that, you can stipulate in there that you want to be notified within 30 days of their having surrendered a lease. You can put in there, failure to comply with that will make this lease null and void. I will tell you from experience that that doesn't work. The courts are not going to uphold that. And there are a lot of things that, again, you kind of have are kind of common sense things. You can put all kinds of things in oil and gas leases and maybe sneak it by the landman or the land company at the oil and gas company, and they're going to they may not be enforceable by law just because it's written there. Remember, you're going to have to prove that in a court of law. The cool thing is that it's going to be held in district court in the county where the property is located. So that means it's going to be held in my district court. And most of these district court judges like royalty owners, which are their constituents, as opposed to big oil. So that kind of works in the royalty owner, mineral owner's favor. But there's no point in, again, that symbiosis. There's no point in putting ridiculous restrictions on an oil and gas company in the hopes that maybe you can break a lease for one reason or another. And breaking a lease, if you can't find someone else to take it, may leave you in a situation where you have no one to market your oil and gas. So that may work against you. So you really need to know what you're doing. Assignment clause is similar. This is just about their assigning the oil and gas leases. This happens all the time. It is really nice to know who holds the oil and gas leases. If you're an absentee a mineral owner and you live in another state, it sometimes can be difficult, but in the days of the internet, you can usually get online. Most of the counties in Oklahoma, you can search records online and you can find out, just search your name, search it by section, township, and range, and find out if there have been any assignments of that oil and gas lease. Oftentimes, land companies will do all the leasing, and then they will make multiple assignments for all the oil and gas leases they've taken. They may hold a few of them back as a leasehold working interest that they want to participate with. Warranty clause. This is a really, this is a red flag clause for me. There are lots of different ways to write warranty clauses. This says that you're going to warranty the title, so that if you lease this to an oil company, remember they're the land professionals and they're supposed to be the ones that go in and verify and be sure that the title is proper. But this basically says that you're going to fix the title problem, any title problems that are going to arise, and you're going to give them the money back if you don't have clean title. So I usually strike that, just the whole thing. I don't mind if they pay any taxes that may be due on the land, which is not the case in Oklahoma because they don't produce taxing minerals. Excuse me, don't tax producing minerals in the state of Oklahoma. Other states they do, and there could be a tax lien against them. That gives the royalty owner, or excuse me, the oil company the right to go in and pay those taxes so that they can have, they don't have to pay anything or any penalties to the state for that. So I usually strike those and try to, if they say, no, we got to have a warranty, I'll have them put a special warranty that says buy through and under. That just means since I got the property, if they find something back in 1910, they're going to have to fix that. It'd only be since I took ownership of the property. If I transferred that into my LLC, then I'll have to fix that, but nothing prior to my receiving it. Exhibit A, extremely important. You should have your very own Exhibit A, if not your very own oil and gas lease as a mineral owner. And when someone approaches you about leasing minerals, you should have a questionnaire right there by the phone, or when you call them back, you say, you should ask them a bunch of questions. How many minerals do you show that I own? How many net mineral acres? What's the spacing in it going to be? What formation are you planning on producing? Is this going to be a horizontal well or a vertical well? You know, and is my title clean? Have you done a title search yet? So just a lot of questions that you can ask them. You may know the answer to all of these questions. It's a good idea to ask them and have them answer, so that, you know, how many net mineral acres do you show that I own? Oh, we show you with 5. Well, if you own 5 and that's what you believe, then you're probably right. If they say you own 2.5, red flag, there's a mistake somewhere. Go and check it. So you can tell them, hey, no, I show I own 5 acres there. They may actually provide you some of the title work that they may have already done to help you update your records. So again, symbiosis, but don't be afraid to ask questions, and remember that everything is negotiable. One of the things that you can do is you say, no, this is our, they'll tell you, they'll come at you with, this is our standard oil and gas lease. There is no such thing as a standard oil and gas lease. They'll say, no, it's a producer's 88. Well, a producer's 88 was just the 88th form that particular printer printed that year. That producer's 88 really has nothing to do with the oil and gas lease. It is kind of a standard form, but I'll guarantee you that a producer's 88 that you see today is not the same producer's 88 that was made back in the 1940s and 50s. So it probably has things in there, like it may say net proceeds realized instead of gross proceeds when it comes to your retained royalty section. And if it says net proceeds realized, you just agreed to pay post-production expenses. If it says gross proceeds, at least you have an argument that maybe you shouldn't have to be paying those. So again, devil is in the details. And if you get this all put together with clauses that you think that you definitely want, like one that says that you're not going to pay post-production expenses, and the first paragraph needs to say something to the effect that this takes precedence over any language that's in the body of the actual lease. You want to know deductions clause. There are several of them that you can write. You want to shut in royalty clause. You know, and again, devil's in the details. You'll see here on this particular one, it says notwithstanding anything to the contrary. And at the bottom of it, it says 2 consecutive years. Okay, that means they have to have closed it in for 2 calendar years or 2 consecutive years from June of 2020 to July of 2022. That whole 2-year consecutive 24-month period, no production. Well, my clause says 2 cumulative years. That means that they shut it in for 2 months and operate it for 2 months and shut it in for 2 months. They do that 12 times, and that lease is available to be renegotiated because they've now hit a cumulative 24-month period. So again, just that one word completely changes the way that is going to function. Depth and pew clauses. You want to be sure that you have a depth clause that says at the end of the primary term, anything below 100 foot below the stratigraphic equivalent of the formation that, and this is where they change, you can say that's actually producing, which would be the way I'd want it, or that was, if they say penetrated, then that means if they drill all the way to the Arbuckle, which is the bottom formation in Oklahoma, that's below the Arbuckle formation, is nothing but granite. No oil and gas below that. If they penetrate all the way to the Arbuckle, then they hold everything above that. Even if they come way back up the hole and produce at 3,000 or 4,000 feet in the Fortuna or a shallower formation, they still hold that the entire stack of all those formations, can go back and drill other formations without paying or negotiating a new lease and paying an additional bonus. The depth clause I have says that at the end of the primary term, if it's not physically producing, it is released. That means above and below what they may have drilled. So anything but what they're producing, I get to renegotiate a new lease and collect a new lease bonus on. So that's a tough one to get. If they drill through it, they usually want to hold it. Oftentimes they will agree to 100 foot below the stratigraphic equivalent of the deepest formation producing. So sometimes you can negotiate that. Pew clauses limit the surface or the horizontal area that they can control. If you sign an oil and gas lease and you have minerals in all 4 quarter sections, and the oil and gas company decides to drill on 160 acre spacing, and you signed a lease without a pew clause that limits them to the spacing unit, then the minerals that you have outside that spacing unit will be held by that lease as long as that lease is in force. So we've bought minerals where someone made a horrible mistake and leased multiple sections on the same lease. And so sections that had never produced were being held by a lease, a 1/8 lease in a section that's was just contiguous to that, was right next door. So make sure you have those limiting clauses that limits both the area that they can produce from, as well as the depths and the formations that they can produce from without renegotiating that contract. So I see we're over time and we have not gotten nearly through all this. I'm kind of just a talking monkey, so you wind me up and I talk. And but this is going to be made available to you, the PowerPoint. So and I'm sure I don't have a problem if you provide them my contact information, and they can send me an email or give me a call, and I'll be glad to talk to you and answer any questions that you have, or I'll be glad to take questions for a few minutes here. I know other people may have other places they need to be. So Tawny, do we have any other questions? Or
so far we do not. Like David said, if anyone has any more questions, just put them down in the chat. And if we don't get to them, or you think of something later, just send it to me, and then I can just forward it straight to David and he can get in touch with you.
Okay. So I'm going to go ahead and continue on here for a few minutes. The access to information clause is a good clause to have. And it's a really good idea to put things in your exhibit that you're willing to not take. And what I mean by that is if I put a favored nations clause or an access to information clause or a right to audit clause in there, and they say, no, we're not going to give you the right to audit our books, that's fine. I'll be glad. I'll give that up, but I want a depth clause. I want my depth clause. Or if they say a most favored nation clause is another great clause. They start with the largest mineral owners first when they start a leasing process, and they'll say, hey, we want to lease you right now you've got 10 acres. And I'm like going, yeah, well, you're the first person that's contacted me about this. How much are you offering? Oh, this is going to be our top dollar. It's going to be $300 an acre and a 3/16. That's the most. We're not offering a quarter. We're not offering any more money than that. And I said, so we want you to go ahead and lease. Well, I want a favored nations clause. A favored nations clause says that if in the next 6 months, and again, depends on how you write it, anyone within that spacing unit or the 8 sections contiguous to that gets a better deal, that you get the right to renegotiate to the best terms that they offered. You can put it in there that if at the pooling that they offer something better than what you got, you get the right to alter the terms of your lease, the royalty and or bonus to match those terms of the pooling or the best terms that they had offered in all of their negotiations. And they usually will say, oh no, we can't do that. I'm like, well, wait a minute. You told me this was the best price you were going to give me. So why would you be worried about doing that? Because they know that there's always somebody out there that holds off to the last minute. And we've all seen what's happened in the oil and gas industry in the last few years with the prices of people purchasing minerals and with the prices of oil and gas being very high. And we've seen the prices of leases skyrocket. Never thought I would get over $1,000 for an oil and gas lease. And you know, a couple of years ago, I leased minerals for $4,000 an acre with a 1/5 royalty, and come to find out, somebody after that got a quarter royalty and $4,000 an acre. So, so I missed out on 5% additional royalty. But you know what? Hey, you win some, you lose some. So,
we have a question.
Good, go.
So any insight to SCOTUS ruling on leases yet? Scots? Scotus? I'm butchering this.
Secretary of the state? Or are you talking about on the decision that changed the decision in the Supreme Court on tribal lands?
The Supreme Court, it says.
Yeah. Yeah, Supreme Court of the United States. Yeah, that we're going to have to wait and see how that plays out. All the case law that had been, you basically have 3 different types of law. You have statutory law that, you know, where they pass the legislature passes the statute, whether it's federal or state. Oil and gas is regulated at the state level. The Corporation Commission regulates oil and gas at, you know, in Oklahoma. The Texas Railroad Commission regulates it in Texas. And most states, I say most states, have functioning oil and gas regulatory bodies, that states that produce oil and gas. So then you also have the EPA and some other things about, you know, methane, escaping methane and some other things like that. A lot of pipeline stuff where they cross state lines, that falls into federal jurisdiction. Well, then you have law that's created by like the Corporation Commission, where it's not statutory law, but it's like regulatory law, where they come in and they say, well, this is how we're going to handle, you know, like forced poolings and things of that nature. And then you have case law, which is where someone has an issue with something, and either the Supreme Court of Oklahoma or of the United States has to define what those previous laws made, and then make a decision, and then that becomes the standard by which situations going forward get handled in the future. And the Supreme Court decision is going to could potentially change a lot of that. And I'm afraid that's above my pay grade. I know my business partner he's been reading a lot of that and kind of telling me some of the stories. The Journal Record has been talking a lot about how there are going to be a lot of changes in not just oil and gas. I mean, it could be a lot of different places. So in a lot of different areas of our lives. So so not exactly sure what the insight is going to be. I think maybe the silver lining to the slowdown in production that we have now is that maybe they get some of this worked out before production and development returns to Oklahoma. I mean, you've got to figure that, 6 months ago, Oklahoma was a hotbed of production in the United States. At one point, Grady County, Oklahoma had more rigs running than any place in the country. And there are only like 3 or 4, maybe 5 rigs running in Oklahoma right now. 2 of them are still in Grady County, but yeah, a lot of those rigs have been moved to other parts of the country. And so we're not seeing the production that we were and the development that we were. And maybe, like I said, the silver lining here is that we don't kind of get caught by surprise on some of these rulings until we have a chance to work out how that's going to happen. So
let's go ahead and wrap up for now. I have some questions that are waiting for you, but I will go ahead and email those to you. Okay.
Okay. Remember, my last slide on here says, it's a quote from a movie with James Garner in it, Favorite Son of Oklahoma. And he says, you don't go wheeling and dealing for money. You do it for the fun. The money's just how we keep score. So open mind, work hard. Everybody have a great day. Stay safe, stay healthy, and best of luck in all of your ventures. And thank you again for being here, Dave. Tony, thank you for inviting me to help share some of this information.
Thank you, David. And if anyone needs a certificate, again, email me today so that way I know that you were in the class. Other than that, thank you guys for all coming out. And if you also need the slides or the YouTube recording, please just let me know. Have a great day, everyone.